Welcome to Fitzanne's Property Exchange, hosted by Pearl Scheltema, designed to keep you informed and captivated about the South African residential property market. Subscribe to our channel today and enjoy conversations with some of the most influential, innovative, and interesting industry experts, stakeholders, and scheme executives as they render input in today's property market.
Hi, this is Pearl Scheltema, the CEO of Fitzanne Estates, and today we are chatting about arrear levies, a rather contentious issue. I think many managing agents feel or share my thoughts on this matter, keeping us awake at night, as we simply don't know what to expect and what is the way forward. And the situation regarding arrears are just getting worse. So today my guest, once again, needs no introduction. I'm speaking to Dilen Heerschop. He is a director at the DTB Attorneys. He is the head of the Community Scheme Litigation Department at the firm. He specializes in the law pertaining to community schemes and compliance issues. He has obtained a master's degree in estate planning law, giving him a keen insight into the financial aspects of community schemes. Hi, Dilen. How are you doing?
Hi, Paul. Very great. And thank you for having me on today's, I must say, interesting podcast. I think there's a lot to deal with.
Thank you so much for your willingness to participate, and I am going to grill you with questions. The most recent court case said that bodies corporate may proceed to sell properties in execution if levies are in arrears with more than 50,000. This gave quite an exciting news to bodies corporate, because everyone now wants to jump on the bandwagon and say, go ahead, proceed to sell. And I am hesitant to become excited too early. So I think I need you to explain exactly what this is about. But before we start, can we speak about arrear levies in general? What would you consider a member of a community scheme's responsibility to pay levies?
Firstly, I think it's a very much so an ungrateful responsibility that a lot of members have. I think when one looks at, for example, arrears with the banks or your bondholder, there's this general fear, that this big bank or this big corporation will foreclose on us, and they will tell us, well, we're coming for your property if you don't pay. Similarly, when we look at, municipal arrears, there's also this general fear that, listen, if we don't pay our utilities or we don't pay our water and electricity, they are going to come and switch off. And in doing so, I see a lot of times that the body corporate is the fund or the person that gets paid last out of this whole situation. I've seen in my personal practice as well where debtors would say, well, I need to pay my bond or I need water and electricity. And it's almost this conception of, what, we don't care. It's the scheme's problem. But
levies are last on their list of priorities.
Yeah. And I think judgments like this just tends to bring people back to reality. It just shows the risk associated with deciding not to pay your levies. Unfortunately, it's not a privilege that the body corporate has to receive these funds. It's a right. So by virtue of one's membership, you must. It's not a, okay, this month, I want to get a few extra things at Woolies and we don't care about the scheme. It's important that you pay it. And I mean, from a body corporate's perspective as well, the trustees have a fiduciary duty. And I mean, I think we'll touch on that a bit later, but it's also important as the management of the scheme or, the directors or the trustees of these schemes, that they've got a right. They have to account to their members as to what they've been doing with these members that don't pay. So I think levies is a double-edged sword. A lot of people don't take it seriously, but on the other hand, judgments like this just solidifies the fact that it's important to pay levies. And I mean, it's the lifeblood of the scheme. So in short, levies is a very important component in our industry. And if that doesn't pay, then you look at things like administration or a whole building getting switched off because the scheme is incapable of adhering to their financial commitments. by virtue of these members not paying. So I think it's definitely an important component in the community scheme wheel.
I totally agree with you. I just want to elaborate a little bit from my own personal experience, and that is that it seems to me, despite all the information that is out there, that owners still don't realize what they bought and the responsibility that goes along with that. I find that levies are definitely in the lower range of priority when it comes to payment. And when they do fall in arrears, the process of recovering these arrears includes sending SMSs, sending letters of demand, and finally then being handed over to an attorney. The problem is just this: if owners are in arrears for a specific period, my suggestion would be that they make payment arrangements with the trustees and then resolve the matter in this way before unnecessary additional costs is added to the levy account. You agree with this?
Yeah, so look, I think from my perspective, whenever I deal with debtors, I tell them that it's not a matter of, sticking your head in the sand and hoping the scheme forgets that you didn't pay them. Ultimately, I think this is where one should foster this open line of communication between the debtor and the management. I mean, life happens. I'm not desensitized to the fact that, 1 month it could go great in your personal finances and the second month not so much. But these types of conversations need to be held beforehand. It's not the scheme's responsibility, which we now have to do, unfortunately, but to reach out to them and say, listen, we've seen it hasn't happened. It should actually be from the debtor's side. So I think a lot of these things can be avoided if there's, frank and open discussions between them. But in most cases, it's the debtor ignores everything and hopes, the body corporate almost forgets about what needs to be paid and hope, in some pot of gold in 10 years' time, we'll get money to pay it, and the scheme simply just has to wait.
Yeah, okay. Could you give us a simple rundown of what this court ruling is all about?
Perfect. So the specific court ruling that you're referring to is Sithole versus the body corporate of Bondi. So this was an appeal by the owners to the Johannesburg High Court. The judgment was delivered in January of this year, and the High Court was asked to scrutinize a judgment to sell their unit, which was handed down in the Roodepoort Magistrates Court. From the outset, any application to sell a unit is an extraordinary and an extreme remedy to a judgment creditor. So as you'll see as part of this discussion, it's quite onerous to get to the point, to persuade a magistrate or to persuade a judge to grant a specific order. When we zoom in specifically into the Sithole matter, but because what we need to understand, when there is an appeal, you challenge certain components of the judgment. You don't necessarily challenge it as a whole. You say, for example, the magistrate made a mistake because they decided the wall is red, but it's actually blue. So that's why you'll see in the Sithole judgment, they don't deal extensively with all of the requirements to sell a unit, but the ones that they focused in on was firstly, the existence of a judgment debt. And I mean, as we've discussed, the judgment debt in the Sithole judgment was for an amount of 43,000 and some change. And then secondly, the specific point of contention was that the debtor said that, or they challenged the body corporate's view that there's a lack of alternatives to executing the judgment debt. And I mean, just to put this in plain and simple language, the debtor said, I had movable property or, a car, a fridge or whatever, which was enough to justify the judgment debt, or that's the allegations. Whereas the body corporate in this matter before the magistrate said there was not sufficient movable property. And they specifically relied on 2 attempts where the sheriff, went to the unit trying to get an inventory of movable property. And the sheriff in 2019 and 2021 came back and said, you know what, we were there. There's nothing of commercial value to satisfy the judgment debt. So we can't do anything at this stage. which then prompted this application to sell the unit.
Mm-hmm. Can we just go back a step, and just for purpose of our listeners, would you mind explaining the recovery process followed by an attorney before we get to judgment or up to judgment?
Perfect. So in an ideal world, and again, this is a less than ideal world, one would think that before a matter is handed over to an attorney, that there's some form of soft collections being undertaken by the managing agent, which would now be like a credit control policy, friendly reminders that you are in arrears, perhaps a few phone calls and SMSs, as you've alluded to. And then it will get to the point where the trustees now, or the scheme executives decide, you know what, this is now where we draw the line in the sand, and we would now proceed. After the instruction,
that would usually be debt outstanding for 60, 90 and more, 90 days and more. Okay.
Yeah. We always encourage a debt collection policy. I mean, get a policy in place. It avoids emotions. It avoids, allegations of the trustees as friends, which they selectively don't, institute action against, and they're picking on me as this poor owner. So I always think, 90 days past, although ultimately the arrears need to justify the financial undertaking that the scheme will now take to try and appoint attorneys.
And these decisions are usually taken at the annual general meeting of the members.
It is proposed to do it like that, because then we all know as a trustee you've got the fiduciary duty. So posing any decision, putting it in the hands of the members, just ensures that everyone's on the same page, and this instruction then came from the members as a collective, as opposed to playing this dynamics of these trustees that are power hungry. So it's always advisable that we do we take these steps and we implement these credit control policies at the members' meetings.
All right. So firstly, it's the soft collections usually done by the managing agent, up to a point where the debt is outstanding for more than 90 days, more or less, and then legal action is taken. So what exactly does that process imply?
Perfect. So the first step is a letter of demand, whether that's a body corporate issue where you deliver a demand in terms of the prescribed management rules, or whether it's a HOA issue where you just issue a normal letter of demand. You would send the letter, place yourself on record as attorney saying, I'm the attorney, this is what you're owing, you need to pay it within a certain period of time. I mean, from a BC perspective, it's 14 days. From an HOA, sometimes the memorandum of incorporation or the constitution, dictates a period. But if it doesn't dictate a period, then one looks at a reasonable notice period. So I always say, if BC levies say 14 days, and legislature thought that's a reasonable period. Normally in HOAs, I also propose that we also do the 14-day period, because then no one can say, the demand period was unreasonable for some other reason.
Okay, so despite the soft collection process followed by the managing agent, the attorney does the same thing before the actual summons is issued.
It's not necessarily a requirement that it needs to be sent by an attorneys, but I've seen in practice sometimes just the fact that, a firm of attorneys have now been included as opposed to the managing agent, they tend to take it a bit more seriously. So there's no right or wrong recipe when trying to get to summons, but it's just important that should one rely on a trustee's letter of demand or whatever, some email that was signed, that it just complies substantially with what is required out of a demand. But it's not necessary, but I've seen a lot of matters where the moment the letter of demand gets sent from our offices, they take it more seriously, they engage with us, and they say, listen, let's try and settle this before it gets out of hand. So it's a quite an inexpensive step to take, which could, avoid a lot of further legal costs going down the process.
All right. So say, for example, all of this has been ignored. The SMSs, letters of demand by the managing agent, finally being handed over to an attorney who sends a letter of demand again, and there's still no reaction. What happens thereafter?
So the next step that one would have to do is issuing a summons, where you would then now, put your demand in the particulars of claim, put the claim amount, add all of the annexures, and then that would go to court, whether that's to the High Court or to a magistrate's court. It would get issued, so the registrar would allocate a case number on the document itself, and then that summons will then be delivered to a sheriff, and the sheriff would then serve this on the owners or owner.
Is that usually at the domicilium address?
Yes, so normally it is the unit, but we have seen some clever debtors where they elect, to change it, which is within their rights, provided that they've informed the body corporate of this change in domicilium. But the default position normally is the unit.
Okay. All right. And then how many days after that is the next step taken?
Yeah. So then the moment the sheriff serves a document on the owners, you would inform them that, listen, if you dispute this, you have 10 court days. So I always say business days, which makes a lot more sense than saying court days, but it's just business days. So roughly 2 weeks if there's no public holidays or some funny thing that's happening, where they must then enter an opposition, where they must now deliver the notice that they wish to defend this particular matter. If that is not received, then it enables the body corporate or the community scheme then to apply for a default judgment. Default judgment just means we've served them. They've not given us any indication that they wish to, defend this matter or, take it to how we could see it in the movies there with all of the witnesses, not a jury, luckily, but witnesses and all of those great things that we see in the movie. So they haven't taken any step that we need to now, know that they wish to fight this. And then we simply say we've served them, their time period for them to defend has lapsed, which is that 10 business day period that I referenced. And then you can lodge your request for default judgment.
Okay. And now judgment has been obtained. What happens thereafter?
So the first step in any process flow that gets you, maybe at the extreme side to sell a unit is to issue a warrant or a writ. It depends on, it's all technical wording. It's the same document. It just depends on whether it's in the match court or in the High Court. But you issue this warrant, which then authorizes the sheriff to go to the property again or wherever the domicile may be, to go and have a look at whether, let's say for the purposes of this example, I'll look at Setole where there was a judgment of 43,000. The sheriff will then go into the unit and see whether there's movable property to the value of 43,000, because ultimately this is what the warrant gives them. It gives them the authority to take possession of this movable property and to sell it on auction in order for the creditor, which would be the BC or the HOA, in order for them to recoup the arrears.
Okay, so let's get back to this court case of Setole. They did all of these steps and they came back with a confirmation that the movable assets could not be sold for the worth of 43,000.
Yes. That's so in the fancy legal jargon, which us attorneys love to use to try and confuse our clients and make us sound fancy, they call it a nulla bona return, which if you had to translate it directly simply means that the movable property does not satisfy the judgment debt. So whether that's 400 rand worth of chairs or whatever, but it doesn't come to this golden number of 43,000 and some change that was in the Setole.
Okay, so and I suppose the sheriff of court often hears that the furniture does not belong to me and that my car is still under hire purchase and none of these movable assets belong to me, etc. So yeah, in 99.9% of the cases, I suppose the nulla bona comes through to say that it was not worthwhile taking possession of those items.
Yes, and I think this is again where misconception comes in. The idea of, this temporary, this plan that they've thought out of saying, it's not mine or, it's my brother's or whatever the excuse may be, but it actually hinders them in the long run because now they've made this, representation or whatever you want to call it, that they don't have movables, which then makes it easier for the body corporate to jump to this extraordinary remedy and say, well, he said he doesn't have it. He doesn't have movables to satisfy, so we don't have any alternatives but to try and sell the unit. So sometimes, the good intention, well, it's actually bad intention, turns out into a bigger predicament.
Yeah, I hear you. All right. So in the Sithole case, it was the debtor defended the matter on the basis of that they haven't been there or haven't tried to sell movable assets. And what was the court ruling at the end of the day?
Yeah, so as I said, I'd love to, after this, just touch a bit on all of the circumstances that needs to be taken into account. But as I said, on the appeal for Sithole, the whole issue was whether or not there was alternatives to execute, i.e. whether they had enough movable property. So what's worth noting is that there was two owners. It was a Sithole and I think a Mr. Ndlovu or something like that. But on the two attempts, Mr. Sithole, who was the appellant, because Mr. Ndlovu or whoever the co-owner was, did not appeal this decision. It was simply Mr. Sithole. And Mr. Sithole said that the 2021 Nilla Bona, as I said, there was two attempts, a 2019 and a 2021 attempt. Mr. Sithole said the 2021 attempt was not right because Mr. Ndlovu was not found at the property, so they couldn't execute. But what the magistrate said in his reasons and what the judges also confirmed and accepted was that the 2019 Nilla Bona was never contested. It was never said there was something wrong. So from that perspective, the court accepted that there was this attempt, there was this Nilla Bona that was uncontested, which enabled them then to see the process through, and which resulted in, the magistrate being warranted in making the decision to sell the unit. Okay.
So now this court case made the ruling that the property can be sold in execution. Where do we stand with the bondholders in this situation?
So the moment there's a bondholder involved, when dealing with the judgment itself, firstly, the moment you as an attorney realize there's a bond registered, they need to be cited as a party because they've got an interest in this judgment. As you just now alluded to, what happens to them? So they need to be cited as a party. They need to be served with the document saying, we as the community scheme, have the intention to proceed with this matter. And then they have their options to oppose or not. What we've seen is they normally take hands with us, say, well, this is our certificate of balance, this is what they owe us. And we then use that information to further justify, to say, let alone them owing us in the Sithole matter, 43,000 in judgment, they also owe the bondholder X amount, which then also makes it an easier sell because then it's this holistic view of, there's debt towards the bondholder.
There's more debtors,
Yeah, there's perhaps debt towards a local municipality as well, and they owe us money. So then the court, when coming to a reserve price, and we can touch on the issue of a reserve price as well.
Please do.
Yeah, when coming to a reserve price, the court would then take consideration of this arrears holistically and see, well, let's say the property, for argument's sake, is worth 100,000 Rand, but they owe the body corporate 50,000 Rand and they owe the municipality 20,000 Rand, then it doesn't take a rocket scientist to see that, 30,000 Rand is
equity.
Yes, but there's nothing more. There's no point in trying to say, this property needs to sell for 100,000 Rand because it's worth 100,000 Rand. But then in addition to that, you then have to pay municipal arrears and you have to pay body corporate arrears because then you're paying 170,000 for something that's worth 100,000 Rand. So that's where the whole reserve price issue comes in. The moment one gets this order to sell the property, just to touch on the bondholder's engagement further with this matter, one would then issue another writ or warrant, which would be an immovable warrant, which authorizes the sheriff to attach the immovable property to sell it on public auction. The moment the sheriff attaches this, another letter gets sent to the bondholder and the local municipality saying, tell us what they owe. so that we can decide, because a bondholder is also entitled to impose a reserve price, to say, you know what, we want a reserve price of 50,000, for example, which then the sheriff has to sell the property on this reserve price of the bondholder. So you're constantly engaging with this bondholder to, you know, get whatever is owed to them and to bring it to the attention of the sheriff and also the prospective purchasers of the property, so that they can decide whether or not they want to purchase the property.
Okay. The version you gave now is the good one, being that there will be equity that you would be able to sell the property in execution to cover all debt. What happens in situations where the debt exceeds the value of the property?
So it will again start with attaching the property, getting it to auction. But again, as we've mentioned, it wouldn't take a rocket scientist in certain circumstances to see, well, you know, the owe 600, but the thing is only worth 200,000, so we're not going to get it sold. Then it still needs to be placed on auction. You know, there's this chance. I still need to see this chance. Maybe it's this unicorn case, and if anyone finds it, we need to study these people. But ultimately, the sheriff would then, if the property doesn't sell on auction, deliver a report saying, this is the amount of people who registered to partake in my auction today. Nobody wanted to bid. This is, you know, all of the debt. And they then send this report to the applicant, which in these circumstances normally when we deal with it, to the body corporate or to the attorneys of the body corporate or the HOA. And then you must go back to court for a reconsideration of this reserve price. So then you would go to court for a second time. It's unfortunate that this is the process, but that is how, you know, unfortunately the rule of law dictates that we can't just do things in a tandem. We actually need to get the court's authorization. So we go back to court, we put all of the facts in front of the table, we tell the court, this is what they owe the municipality, this is what they owe us, this is what they owe the bondholder. Please give us a direction as to how we get to sell this property. And in those circumstances, then the court would, you know, either reduce the reserve price and say, you know, the bondholder is being a bit unreasonable to expect this huge reserve. So they would either reduce the reserve price, or they would just say the property needs to be sold without the reserve price.
So that is indeed in the power of the court to do so.
Yes, but that would only happen, you know, after the auction and all of this process happened. Yeah.
Okay, so what is now going to happen with the Sithole case? Being it very recent January, I suppose all those steps have not been implemented yet to have the property actually sold in execution.
Yeah, so it depends firstly on the attorneys dealing with the matter, because sometimes you get attorneys that drag their feet. But I mean, in an ideal world, if you look at this stage, hopefully a warrant of execution, the immovable warrant, has been issued. And it's somewhere in the pipeline with the sheriff, where the sheriff must now inform the deeds office and note an interdict against the property, or inform the bondholder and ask for the COB, or, you know, going to attach the property. So there's a lot of services that the sheriff needs to comply with. And after he has successfully attached the property with all of these components, then he would give you an auction date. So in an ideal world, I would think there's an auction date for this property already. In a less than ideal world, I would think the sheriff is still busy, you know, serving and attaching the property so that they can get it to auction.
Okay, now the legal costs that have piled up to this date, whose responsibility is this to pay?
So when one looks
the applicants or the actual debtor? So
firstly, it depends on the costs that get allocated at the court hearing itself.
Okay, so there will be a court ruling to say who's responsible for these costs.
Yes. So they would normally, and this could be punitive costs, for example. So if the court feels like, you've been misleading the court or wasting the court's time, or, it all amounted to a delaying tactic, then one would get a punitive cost order, which would enable one to tax more out of the process, or one would get a normal cost order, and then you would look at the magistrate's court tariffs. But something that's very interesting is with the Marsh Rose case, and I don't have the specific paragraph in front of me, the court formulated the view that you, as this investment purchaser at the auction, because there was a trend at auctions where prospective purchasers would purchase a unit and then after the fact start disputing, all of the charges on an owner's statement, because it was a model to try and get the best margin or equity out of the deal, where the court said that if there is any party that could dispute this, it's the sheriff, because the sheriff at that point is acting in almost a representative capacity. It's a court-appointed capacity, selling the property on behalf of the owner. So it can't be that this outside party who purchased it, who signed an agreement and committed to the fact that I understand the arrears are 200,000, whether that is 100,000 of legal fees is of no consequence, because I signed this agreement saying that I'm happy with the fact that I need to pay 200,000 rand. I've been informed of that fact. So the court, actually, the Supreme Court of Appeal came back and said, well, monies due includes legal fees. So from an auction perspective, one would normally recoup all legal fees as was paid by the body corporate or the HOA to get to the execution.
That's good news, because I think most scheme executives are hesitant to embark on this journey purely as a result of the costs. So it would be good to include a ruling on the costs before one proceeds.
Yes, yeah. And ultimately, it's again a double-edged sword. So yes, it's expensive. In life, things are expensive. I also feel, my medical aid is expensive and I'm just throwing money down a pit. But unfortunately, sometimes it takes money to make money, almost, if I can say it like that. So the options are leave it. Maybe it gets worse. Maybe the debt prescribes. Maybe, we as trustees are held fiduciary, personally liable because we've done nothing. So that's the one side of the sword, to try and save money. On the other side, expend the money, get this habitual non-payer out of the scheme. And I think the scheme as a whole would benefit by getting a new bona fide purchaser, bona fide member that actually pays their dues. So it's a difficult decision, but it all tends towards, proceeding with legal and getting this person out, because it's a benefit in the long run.
Yeah. What I'd like to ask is, you have now in depth described the whole process of recovery up to the point of selling the property in execution. Are there any other legal ways of recovering arrears except for the process you've just explained?
There's definitely, this is not necessarily legal, but it's a settlement perspective where we can enter into AODs and the person pays. Another option is looking towards terminating water and electricity. This is a very, very controversial topic at this stage. It's difficult to say whether it's right or wrong. We've got judgments in Johannesburg saying that you're not allowed to do it, and applications being dismissed. But then in the same breath, we also have judgments in Joburg saying it's fine, do it. It's a way to mitigate risk. So bringing this application to limit water, we can't cut off water completely because it's a constitutional right, and to terminate electricity is an option, but ultimately we just need to consider the fact that there's a huge risk that, depending on the judge, depending on their views, you may find that some judges will grant it and some judges will simply refuse to hear the matter. So it is a bit of a predicament and it is a bit of a risk. So at this stage, it's difficult for me to suggest doing it, because I don't like, working on probabilities. I like to work on things that I can control in my practice, but it is a method that one can try. But again, going through the process, getting the property sold, it may cost the same as bringing these types of applications. And then you've got more certainty. That that there's not this conflicting view of yes or no. It's, if you draw the wrong judge, it will get dismissed. There's a lot more certainty when looking at these types of things.
I'm going to express a personal opinion, and I might not be very popular for doing so, but this cutting of electricity has always been an issue for me. The local town council provides electricity up to the distribution box. Anything behind that, the circuit breaker being the distribution to the individual units, in my opinion, is the body corporate's property. It's the body corporate's responsibility to maintain. The body corporate pays a circuit breaker fee to the local town council for having that. So if that from that end is being disconnected because of non-payment of levy, I really can't see that there should be a problem with that. But okay, there are much more clever people than me and legal issues. So the bottom line is you can't cut electricity without a court order.
Yes, Paul. So I'm inclined to agree that it is definitely a frustration from a scheme's perspective that, should an owner not pay their arrears, that it becomes, this almost appetite where one wants to actually terminate the electricity. But one just needs to take cognizance of the fact that we do deal with spoliation, which simply means the court frowns upon self-help, which is, taking the law into your own hands and doing stuff without the court's involvement. And that's why the court actually, focuses on the fact that one should bring an application to terminate the electricity. And once it's authorized, then you've got the full power to do it. From a practical perspective, I always also suggest that, when it's within a scheme's financial capacity, to look towards looking at prepaid water or prepaid electricity meters, which then and oftentimes curtails a lot of these expenditure that the scheme incurs on behalf of these members. So then it changes the narrative from all of these members that actually needs to contribute towards the arrears, and that they're actually, suffering at the hands of this one person who does not pay their water or electricity. And it changes the narrative to, if they don't want to pay their own water and electricity, it becomes their issue, because they need to then contribute towards, prepaid meters and so on.
Yeah, we can talk about this for years, but nevertheless, I am going to ask you only 2 more questions. What advice do you have for homeowners and trustees to avoid disputes and ensure levies are managed properly?
The first thing that I must say is one should have reputable managing agents. Look at Fitzanne and these types of managing agents. They know what they're doing. So one would need to firstly ensure legislative compliance. So looking at the Sectional Title Schemes Management Act, now specifically talking for bodies corporate, looking at the prescribed management rules and the regulations, there's a lot of intricacies, and nuances as to how one should do A or how one should do B. So having the right professionals is, I think, then you're 80% there with trying to deal with these issues. Because the biggest can of worms as a scheme that you can open up is, we've posed these budgets, we've charged these people according to our budgets, but we never took the steps to try and ensure that there's compliance. Or we've raised the special levy, but we haven't done it right. So I think 80% of the way is getting a reputable managing agency or property practitioner to assist you, because they are ultimately there to guide you. Unfortunately, in the industry, being a trustee or being a director, it's an ungrateful job. You are a CA, or you are an engineer, or you are whatever you are, and you have to take this on as an additional responsibility. So a lot of times they are not the experts in the room, but they try and conduct themselves as if they are the experts. So getting a reputable managing agent is a must. It's not even a subject for debate. Secondly,
thank you for that vote of confidence. Much appreciated. All right, my last question. Do you foresee any future legal challenges or changes to this ruling that property owners should keep an eye on?
I don't think so. So what we need to understand is there's this whole can of worms, and there's a lot of requirements when one looks at applications to sell units. But remember, with an appeal process, you only specifically deal with certain components. So with this component, they had a look at lack of alternative means to execute on the judgment, i.e. whether or not, the person had movable property to justify. The court basically with this judgment said, the fact that a sheriff went out once and it's uncontested that there was nothing means that they have attempted to execute. I know there's a dispute on the second component, but what this seems to suggest is that one attempt could be sufficient. I mean, in practice, I always propose do it more than once, or if there's tenants, try and trace the person to go to that person's specific address so that you just satisfy yourself with the fact that there's no alternatives. But I mean, in a context where you bring an application, and I'll be very brief with this, but the factors that one look at is information pertaining to the property. So this is the market value, municipal value, whether or not there's debts owing to bondholders or local municipalities. Another important consideration is whether this property is the primary residence of the debtor. Information pertaining to the arrears. So the one thing that this judgment doesn't deal with, but it wasn't per se challenged, is this judgment was granted in 2019. We all know that levies accrue monthly, which means that there was definitely, I would say, an increase in arrears, and it was
in the meantime, for sure.
Yes, yeah. which was not a point of appeal or point of scrutiny in the appeal. So those things are important. The circumstances under which the debt arose. So from our perspective, these circumstances are membership to the owner's membership to the community scheme. So it's not an Edgar's account. You become a member, so you are liable for these things. One must look at the relative financial strength of the creditor and the debtor. Sometimes, we don't have all of the information about the debtor, but where we do, where the debtor has provided us with bank statements, for example, they want to enter into an AOD and we scrutinize, their finances, then we must go to court and say, listen, this is what has been disclosed to us. If there's nothing, I mean, you can't draw blood from a rock. So if you don't have information, you can't. But if you have, you need to also disclose that. And then lack of alternative remedies, which, I mean, this was the crux of the Sithole matter, whether or not there were, alternatives to this application. Something that also needs to be given regard to is whether the property, was acquired by means of a state subsidy or with the aid of the state, and then whether the debtor will lose access to housing as a result of this execution being levied against their home. So, if it's an investment property, it is not as difficult to get the executability order as if this is the person's primary residence, they've got no other place to go. So there's really a plethora of requirements that we need to consider. But if we zoom in on the lack of alternative means, I don't see how this could be challenged. The simple fact was the sheriff was there. The sheriff asked them for money or movable assets, and the indication was I did not have any. So I don't think there would be challenges.
Okay, thank you for that. So I was right in the beginning by saying we shouldn't get too excited about the heading properties can now be sold if levies are in arrears more than 50,000. It's not that easy. There are quite a lot of things to consider. Dilen, as always, your input was quite insightful and enjoyable, actually, and just to refresh the whole situation. Thank you so much. And if you need to be contacted by any of our listeners, where can they get hold of you? Or can you provide us with a website of your company?
Yes. Firstly, Paul, it's always a privilege being on this podcast. I think you guys are doing amazing work with trying to educate the industry. I think we need more property practitioners and managing agents, that take the time and effort. I mean, this is not something where it's a billable thing, or it's something I can see it's because of love for the industry. So big ups to that. I think it's amazing what you guys are doing. And I hope, that there's still a very bright future with all of your endeavors and all of these amazing things that you bring to the industry. From my side, as you've mentioned, I'm from the DTB Attorneys. If they want to get a hold of me, they can look at www.dtb attorneys.co.za. Alternatively, I believe that my email address would be published on the podcast advertisement if they want to contact me directly.
Thank you so much. Listeners, I hope you found this useful and we will talk again. Thank you so much.
This was Fitzanne's Property Exchange, hosted by Pearl Scheltema. Not only do we keep you informed on the very latest in the property industry, we also empower by expanding your knowledge base. Make sure to visit www.fitzanne.co.za to find out more about sectional title scheme management, letting, sales, and trustee training. Remember to subscribe to our channel and follow us on all our social platforms.